Hello, everybody. Hi, Ava. Hello, C-Rex. Hello, Lisette Panette, my dear. Hello, Nana Laura. Hello, Sir Philip. Oh my goodness, I miss you. How's my bearded hero? Right there. 14 months. Oh my gosh, I love you. Thank you so much. I really do miss you. We all do. Hello, Mortimer Duke. How you doing? Hello, Eileen E. Carlin, sweetie. Hello, K. John Boom. Good to see you. You're not chopped liver. If anything, you're, diced Salisbury steak. I don't know. I love you. You're too cute. She does have that forever puppy face. Right there. Look at that. The forever puppy face. A nice creamy pate. you know, we could just bypass the meat section altogether and just say you're creme brulee. I don't. I'm not a fan of liver. Never have been. I've tried it like so many times. Like it smells good sometimes when people are cooking it. And I'm like, oh, maybe I like it now. And I never do. Oh, Bandit honey. What you getting into there? What you doing? There's no more treats up here. You have food in your dish that you refuse to eat. She's all of a sudden got picky. And, there's 20 pounds of food left and she will not touch it. She just waits for the treats. KJ Adele. The kitties like pate. They sure do. She is. She's my dog, of course. Oh, it's a good one. It's a good two. And I got tomorrow's ready, so I can do day shift again tomorrow. I'm hoping this is a thing that I can sustain, because I gotta do day shift live, night shift live, and cut them all up into replay crew minis. I need an intern, y'all. I need that helper, and I hired a guy on Fiverr to help edit. And I paid him to do 2 live streams, and I had like 3 usable videos out of everything that he did, and one of them I had to edit myself after he edited it. So I don't know that I really want to do that again. Hello, Spider-Man, honey. So good to have you here. Always. I agree.
On the record, please. Court calls case number 257894DS. Gola v. Spahn. This is the defendant's motion regarding custody. Both parties are present. Would you both please raise your right hands? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. This appears to be an initial determination because this began as a support matter provided through the prosecuting attorney's office. And in the order of support that was entered on February 27th, last month, there was support ordered on an interim basis. The court ordered joint legal custody, and on an interim basis, the court ordered physical custody to the plaintiff, Mr. Gola, in this matter. And the plaintiff shall have sole physical custody of the minor children until the defendant requests a hearing and a front of the court investigation into custody and custodial time. And the order will stay in effect until such hearing comes before the court and the court makes their determination. So I'm assuming, Ms. Spahn, you are indeed requesting that to get this process moving forward, yes. Correct? Okay. All right, and the court had entered an interim order regarding the status of custody, physical and legal, joint legal as to both parties, physical to father. And were you at the hearing originally back on February 24th?
It was over Zoom, but yes, I guess, kind of.
Okay, so what is the proper cause or change in circumstance since the last hearing?
At the last hearing, I was in jail, unfortunately.
Why were you in jail?
It was a long situation.
Is it a pending criminal charge or is it a criminal charge that's concluded? Is it a failure to pay on a ticket?
No, it was a situation with some friends. We all got locked up. We were all just drunk. It was really bad. And we all got locked up. I ended up walking away with a misdemeanor, everyone else with felonies.
What was the misdemeanor?
Assault and battery.
Upon child or?
No, another adult.
Okay, so.
Your Honor, I'm gonna just kind of stop that right there because I actually represent her in that matter in Tuscola County. Yeah, so I would prefer her to not talk about anything like that. So.
Okay, well, I don't know what's going on.
I don't, yeah.
For the record, Ms. Jessica Risky stood up and made comment. Okay. So what's changed since February 24 that you believe that I should review the interim order?
Everything between me. I have, from being in jail, and oh my goodness, I'm sorry, I can't speak, I'm nervous.
I require you to stand too as well.
Oh my gosh, I'm sorry.
I apologize.
I attend AA every Wednesdays just because alcohol was involved. I am sober off of everything. I don't do anything. I work all the time. I have a good job. I live currently with my mom, which doesn't sound good, but I have a great support system. I just think it's better that the kids have both parents in their lives instead of just one. I think it would benefit everyone involved for both parents to be involved in the children's lives.
Okay. Is there any parenting time at this point?
For me, no.
This is a motion regarding custody. Okay. Sir, your response.
Do I need to stand for it?
Yes, please.
I would like to keep and retain my full custody. Their living situation is not plausible. There is more than 7 people living in a 3-bedroom house. Their living room has been turned into essentially an Airbnb. There's mattresses for everybody to lay down on. They sleep in recliners and on the couch. Where I reside in Ubley, each individual kid has their own respective bedroom. I have my own respective bedroom. We rent out the entire upstairs of the house. There is no shared into groceries and stuff. Like I have my own. Wow, I'm trying to think. It's I provide for them all on my own, like my roommate doesn't help with me. My dad and my little brother, our third party contact, are the main babysitters for myself right now when I don't, or when I have to go out and do job interviews and stuff for work.
What are your thoughts about mom having parenting time?
If she can do multiple months of the AA, because I know I have text messages proofs that she was drunk while caring for our son.
There are 3 children, correct? Two, sorry. Okay, but you're saying mother is not fit to have any parenting time with the child, even supervised?
Supervised, maybe, but not by herself, no.
If it were supervised, is there a supervisor that could monitor this?
My father,
What's your father's name?
Pat Gola.
Are you able to supervise it?
I have no contact order with her, so I would like to keep it like that.
What's the no contact order based on?
The domestic violence that we were supposed to have yesterday, but Judge Harrington wasn't here for the,
Oh, there's a charge of domestic violence?
yeah,
And who's the alleged victim?
she is.
Who is the person alleged of committing the domestic assault?
I am.
But there's a no contact provision.
Yes, that she has broke multiple times.
Oh. I'm assuming front of the court has no third party supervisors. They want to pay. Well, mom's working, she testified. Dad, are you working? You may be seated.
Oh.
Are you?
I
working?
have classes with Michigan Works to work on getting my CDLA. So that's what I'm.
But you're not working right now.
No,
What does it cost?
They're currently charging $25 an hour full mileage. I do have a very limited remainder of access and visitation grant funds left for September. I think we have $300 for a couple hours.
You have a proposed supervisor,
I do not.
family member, close friend.
My mom isn't working right now, so she could.
What's her name?
Shanna Seeker,
How do you spell the last name?
Theaker.
You said Shannon.
Yep, no, Shanna, Shanna.
Shanna, okay.
Sorry, it's common, happens a lot.
Are you familiar with Ms. Speaker?
yes,
Any problems with Ms. Speaker?
yes.
What are the concerns?
She is very also mentally unstable. I've witnessed herself hit herself in the head when she ran out of weed. So she's an addict.
The domestic violence allegation. When is that going to be resolved? Is it a trial or a plea or a dismissal? Any ideas, sir?
Yesterday, Miss Weisenbaugh said that we were gonna move it for trial.
Ms. Weisenbach?
Yeah.
Ms. Risky, you represent Ms. Spahn on what type of matter?
I represent her in the Tuscola County matter, the assault and battery charge that she had alleged. But for the record, I want to make it very clear, I cannot give her any type of advice in this case at all.
I'm not asking for that. I just want to know who's the alleged victim?
It is not this party.
But if it's not, who is the alleged party? If you know.
I don't know. I mean, I can pull it up for you real quick.
No, but it involves somebody at least,
Correct,
an A and B charge.
correct.
And that's why she was in jail before, back in February when the court had.
Yes, Your Honor, and an offer has already been extended to her for HYTA, so I'm assuming there's not much that's gonna be coming of that. An individual. There are two separate counts, Jaden Allard and Taylor Jones.
2 counts.
Correct.
First and foremost, thank you. The court is going to make a ruling at this point. The court is going to order a friend of the court investigation regarding custody, parenting time, and support. It's an initial determination. It's initial only because the current matter before the court was on an interim basis. At the time the court entered that, the defendant was in the Tuscola County Jail. Now I hear father is charged with domestic assault against mother. There's a no contact provision involved. This is a motion for custody. Prior orders are going to continue as previously stated. Regarding any parenting time for mother, I will require the parties within 21 days from today to submit names of individuals who could supervise the prospective parental or parenting time for mother. Those names would be submitted to the friend of the court. And I need 3 names. If you only have one, I guess you only have one, but no disrespect regarding the parties here. Patrick Gola or Ms. Leaker should not be on the list because I need someone, frankly, that's impartial, that can just monitor the visits so that the children are safe and there's no protection of either party. In other words, if defendant's mother is the supervisor, there's the possibility of trying to protect any alleged problems. Same with Mr. Gold. 3 individuals, if you have 3, submit it to the front of the court within 21 days. If you fail to submit it within 21 days of the court, or we don't get it, then at that time, the court will deny the motion and continue the prior orders.
And this judge, he will look up the names of each individual submitted by these 2, and he will verify that they don't have pending charges against them. This judge is very thorough about stuff like that, and you would never know it by how he's talking to you when he's asking for those names or, asking for details about things. He's got a really great poker face. He doesn't show his hand until the very end. And when he gives his ruling, you're like, oh, he did hear that.
That's all I can do. This is a mess. That'll be all. Thank you. I'll be right.
Michigan versus Heath Markham. This is file number 2516-FH. Appearances, please.
Joanna Carey for the people.
I'm Jeff Harrison. I'm here for Mr. Markham. Mr. Markham is appearing by Zoom.
Thank you. Mr. Markham, are you able to see and hear us, sir?
Yes.
Thank you. All right. We are here today for, looks like, a motion.
It is.
My recollection.
I can briefly outline the circumstances. They're not difficult.
Oh, my thunder.
Yeah.
Didn't we, wasn't there a bond violation, a probation violation?
There is, because he's on probation in Misaki,
Okay.
and that remains in the air.
So
We've communicated with them, and they said, depending on what you rule, they may even.
well, is he on probation and for circuit court over there?
I believe so.
Yeah, so
Yes.
should I be calling both cases?
I don't suppose that would hurt anything,
Well,
although we don't have a Misaki prosecutor.
And we don't have the file.
and we don't have who?
The file.
Oh, yeah.
We don't have anything.
Well,
We're prepared to
Alright.
deal with that contingency anyway.
okay. Because I think, didn't I revoke the bond, remand him to custody on the
Did.
PV?
Well,
So
and you
whatever.
did here as well.
Yeah, but I'm saying, all right, Mr. Harrison, why don't you go ahead and tell them what's going on?
So I guess the nomenclature that you're looking for, judges, we're actually asking you to reinstate bond
Yeah, but.
as a PR.
Right. So hold on. We're here for the 2025 file. And it's my understanding he entered a plea
Mhm.
in that case, correct? And we did that here last week.
Yep, it was about a week ago.
And then that also must have resulted in a probation violation for the Misaki case.
It has.
All right.
So that's nailed down. They're just awaiting sentencing, much like we are.
And you said something that confused me. So is he also on probation in this county, or is it just the two files? Two files.
It's just the two files. Yeah,
Copy
I'm
that.
sorry.
It's all right. I got it. We're good. All right. So now you're seeking a modification of bond in this file.
Indeed.
And if I rule on it in the way that you're asking, I still have to rule on the
Misaki.
bond in Misaki County. So it seems a bit premature. And as we all know, I'm not in the office next week and I leave today by 3:30. So.
We are anticipating obtaining a stipulation
Okay.
from the prosecution in
All right.
Misaki County as to that other case. That's
Okay.
why
All right. So
we're happy to have this early in the morning. So we've got all day to get that done.
Sounds great. All right. I just wanted to make sure that we were
Yep.
On using our time efficiently. Because I didn't want Doge to come down on us.
I have to say that Sierra reminded me of all of that Wednesday. So we planned ahead.
All right, good. All right. So now that we've covered all that, make your pitch.
That's Sierra Golden, by the way.
Yeah.
My pitch is quite straightforward. As the court knows, Mr. Markham has a serious record. He has a multitude of
I know.
offenses that all involve substance abuse. One element that has been missing is his successful participation in treatment.
Has he had treatment I'm sure he has. If I recall, he was at one time a treatment provider or counselor of some sort. And I know he's had multiple convictions. I know he's had prison stints in the past.
Well, and I'll bottom line it for you here. Obviously, it's no secret to anyone in the room. He's going to be 10 to 28 on this file.
Yeah, it's
Because
I would imagine.
so, in all reality, he's in a straddle cell that could very well earn him another short prison sentence. That notwithstanding, I want and he wants him, whatever process, whatever is the next step in this journey, he wants to be able to do that with the assurance that he has the tools to maintain his sobriety. I know that there is programming involved in the prison. I know also that Mr. Markham has participated in that. So we think he needs another level of intervention here. I think right now is the perfect time to do it because it would easily slot in before the sentencing in this case. If we had to adjourn it a week or two, no big deal. And we could get him, whatever occurs, we're not believing that a prison sentence is a foregone conclusion, but the reality would suggest that it was likely in this case. But we want him to be able to take with him into prison the fact that he's completed a rehab this recently. I think it's important for his mindset in that regard as well.
All right, let me go back to my original question, and that is looking to have a better idea of what he has had. It would be beneficial for the court to have his probation officer available and or the most recent PSI. certainly that PSI would not cover what kind of treatment he's had since the last release from confinement. I know he had the case over Misaki County. I remember images of the case had something to do with operating in a car and having something inside the car. And did I give him jail or did he get, well, no, obviously if he's on probation, yes, I gave him jail, sorry.
And I don't know if that sentencing has been completed yet because of the,
Well, he's still on probation, so he had sentences.
the interposition of this case on top of it. As is common when there's new charges that also create a PV.
I understand. Miss, well, I'm pausing and turning to Miss Carey because I really would like to have that information. Because I want to know what is different this time. And I want to know what he's had. Now, by the way, I have seen defendants obviously get up to this level and have never had an inpatient program, surprisingly enough. And I don't think one stint of inpatient is a magic pill that solves a substance use disorder. I'm not that silly. I'm silly.
I would just make a blanket statement, Your Honor, irrespective of his former attempts at obtaining sobriety. The one thing that I see that's the major difference is this time is his state of mind and his desire to get clean and stay clean that I can honestly say was lacking in prior opportunities, unfortunately.
Well, Ms. Carey, I'll turn it over to you. I didn't want to ignore you. No, go ahead.
So he is scheduled for sentencing on April 14th. Frankly, the people are just flat out opposed to releasing him to treatment at this time. He pled to possession of meth and possession of cocaine as a habitual offender second. His prior history back to 2017, he has a delivery manufacturer of cocaine, a delivery manufacturer of marijuana, both as second offenders. And what I don't have is what the first conviction was. So I don't think that we have a complete criminal history.
Yeah.
He also had a maintaining a drug house second in 2022, disorderly domestic violence, possession of methamphetamine again, and then it goes back to 2002. So I think there's a gap in the information that we have. So I'm not sure. I did estimate the guidelines at 10 to 28 based on the information that we have, but I think
Was that as a second sub or was that as a
Have to.
Have to.
have to.
All right.
And so, but I think we're missing some information.
Yeah.
I think there's some convictions that we are missing.
Well,
He had methamphetamine, cocaine, psilocybin, which wasn't charged because we didn't have it tested at that time.
Tell me a little bit more about that in the new case, the 2025 case. Give me a description of what it was, what amount, for instance, is this a residue case? Is it a dime bag? Is it, I said dime bag, by the way. I don't even know if I know what a dime bag is, but
I was thinking.
everyone always holds up the little finger with like about an inch, so I figured.
It's okay, Josh.
It's all right. Thank you, sir, in the gallery. I appreciate it, sir. Thank you.
Yeah.
All right.
If
Okay.
I'm reading this, one container had 5 grams of meth, one had 16 grams of meth, another had a gram of cocaine.
A dude in the gallery is helping the judge understand what a dime bag is. He's like, I got you, judge. This is what it is. Oh, man.
A gram of heroin, 32 psilocybin or 32 grams of psilocybin, a scale, cotton swabs, another 10 looks like psilocybin, another 1 psilocybin, So
So,
it's,
and where was all this located? Was this a
it was a
probation or a traffic stop?
traffic stop. He was pulled over on River Street, from Mitchell Street, and it was all in his vehicle. He was the only occupant of that vehicle.
That's a lot of stuff.
It's a lot of stuff.
That's a rolling drugstore.
So I don't know what his prior things are with rehab. I think it's interesting that he didn't have successful participation is what the term used by the defense was. Well, you have to participate and you have to try. And so that term kind of,
And I acknowledge that sometimes people, it takes,
I don't,
I
I
get
didn't mean to load up the term necessarily. What I meant was, obviously, there was some
yeah,
lack of success in whatever former treatment he's had.
obviously. and
That's
I-
what I meant.
we
And I
understand
understand.
that.
I'm sorry.
I'm sorry, go ahead, Miss Carrie.
So frankly, this close to sentencing, just don't feel like he's a good candidate for release at this time. These were serious, and he did so while he was already on probation. So I think if we did have a PSI, which I don't, he's had this opportunity before. I know sometimes it takes more than one, but those opportunities will still be available to him after sentencing. Thank you.
One second here. Ooh, we got a lot to do this morning. Mr. Harrison, what is your afternoon like today?
Wide open, there are no arraignments.
And mine is not. I have a preliminary exam.
Oh, that's right.
All right, well, that's Mr. Denham. What time's your prelims begin?
2.
All right.
We file a set for a hearing on April 7th. First Monday. Or no, it's the
So,
following
yeah,
week. It's the second.
7th would be I come back on the 31st, so it's the following week.
Oh, yeah. 'Cause
Yeah,
next week
I'm looking here, I see that we've got some
Jeez, I can't believe that.
potentially tight, but some potential availability at like 1:15.
Here,
I'm sorry?
if we're done here.
Yeah, if we're done with our morning. Or, is Mr. Carnes involved in your prelim or whatever today? Sorry.
No, he's not.
Yeah. The reason I'm thinking is I want to look at the PSI. That's what I want. If I had it right here, I could look at it and answer this motion right now. So. Could we be here today at 1
We
o'clock?
can. I mean, I guess in the alternative,
Okay. Madam Clerk, what's the jail? I don't, is there a correction officer in the background there?
Yes,
Judge.
Corrections officer, is there anything that goes on at 1 o'clock there at the jail? Like, would I be interfering with, chow?
No, sir, we're finished by then. I don't think we have any arraignments as of right now, so 1 o'clock shouldn't be an issue.
All right. I'm gonna adjourn this to 1 o'clock today. Maybe the corrections officer can just give a hint to the jail administration, but I'll, of course, have my staff to take care of that. Again, the reason for wanting to do this is to take a look at what he's had. Now, I have allowed people with extensive records to go do a program. And so
Okay.
I'm thinking about it. I'm not shutting it down, but I do want to see what his PSI says. And I'm also going to see if I can get his PO online today. Mr. Markham, who is your PO over in Lake City? Is it
Luke
Luke
played.
or
Luke, yes.
All right, I'll try to get Luke on Zoom with us today as well. I want to know how else, what else is he done since he's been on probation. Was this a first PV? I don't, stuff like that. So I want to have a little bit more information about what he has done in the past, and so forth. All right. Thank you very much for your patience as I walk through all that. We'll be back today on the record here at 1300. Thank you. We're adjourned.
And they did not come back on live. I don't know if they just went with the adjournment. I don't know if the other party wasn't available or what the deal was, but I checked the entire docket, and I checked for another stream, and they didn't come back with the update for that case. So, but I will be keeping an eye out for it.
Mr. Burdette, we're going to take care of yours, get you out of here. Back on the record, and this time we're taking up the case of People of the State of Michigan versus Darren Root. This is going to be file number 24-13939FH. Appearances. Now I see an assistant AG on the screen, Robert Hayes. Mr. Hayes, we were expecting Mr. Dobie. Are you covering for him today, sir?
I am, Your Honor.
All right, thank you. All right, we are here today for a final pretrial conference. Ms. Fervento, what are we doing?
Thank you, Your Honor. We would, and again, Taylor and Anna Fervento on behalf of Mr. Root, who's present seated to my left. Your Honor, we would respectfully request that the court exclude evidence from a cell phone dump that we were just provided yesterday. I have not even had the full opportunity to review that because we got it yesterday afternoon. It's my understanding it's a very large file. This is related to the phone that we have already adjourned over multiple occasions. Because of, and again, I was under the impression that there had been some pictures or screenshots that were taken and then put onto a Wexler County server, which was impacted by the hack. I recently learned that was not true. This was a phone that was in evidence at MSP, so not affected by the hack. And for whatever reason, no one was actually just running a report on it. For that reason, Your Honor, we would be ready to go to trial on the 8th, but we would respectfully request that the court exclude all of the information from that phone, the picture. There's no pictures, it's just some text messages, that it all be excluded from trial due to untimely disclosure. Thank you.
All right, Mr. Hayes. Go ahead, sir, go ahead.
It's my understanding that certainly we've made diligent efforts to get that information. However, it's not in the prosecutor's possession at the moment. We have made every effort to get the full text message and text messages, phone dumps, everything, but it's going to be a large file. That is, according to the OIC, that will be delivered to the defender's office or to the defense counsel, I should say, and then at some point given to us as well. There have been some screenshots taken from that which have been turned over, but there are not, like, we don't have the full phone dump. The people are requesting the court to adjourn the trial, allow us to review.
Go ahead. I'm sorry, I didn't mean to interrupt you.
No, it's fine, Your Honor. We're just requesting to adjourn the trial, set another final pretrial date, and allow us to review the phone dump, allow both sides to review the phone dump, I guess, at this point.
One moment. I just need a moment to take a look at my notes from our hearings. All right. I'm sorry, go ahead. Do you have anything else, sir?
No, that's it, Your Honor. Thank you.
All right. I'm sorry. I thought I heard something. All right. Well, back on February 7th, there was a direction by the court to make sure that all discovery was done within a week. We'll note that this case, the alleged events occurred on June 22nd of 2023. The case has been filed since August 5th of 2024. While the defendant, however, is not currently in pretrial confinement, the court obviously considers that underneath its requirement for speedy trial. Court is also takes a look here, and this is the second oldest trial that is currently set on the trial docket. I anticipate that the one that's currently up there is number one is likely to go. However, this phone thing has been a topic of discussion for months. And the answer is no. The court will not adjourn the trial date. The court will keep it set for April 8th. However, the court will not exclude the material because of what it is. So you all got a couple weeks to figure out what's in it. And then the only thing that you're going to be able to, and then you're going to have to tell me why there's a prejudice and why I need to adjourn it. So am I likely leaning to the defense that I'm likely to exclude it? Potentially, but I don't know what it is. For instance, whenever you do these phone dumps, and I don't know if this preventative has dealt with them, they are thousands of pages, but they're really easy to figure out. You don't read 5,000 pages. There are thumbnails at the bottom. You can click and do a search for certain phrases, and it ends up being very, very simple to find text messages. And then your only challenge would be, Judge, I need an expert to examine a phone dump to make sure it was done. But I'm pretty sure I've mentioned that in the past. So if the defense doesn't have an expert, then the defense is well behind their own obligation to get one. So, and by the way, your challenge for a phone dump is pretty simple. They use a Celebrex device. You can go on the webpage for the company that makes it. They even give you a sample expert foundation laying. And, you know, if they can't get it in and they don't lay the proper foundation, then I'll exclude it. Otherwise, you can go get your own expert, which you've known with us as what was coming. You should have had it lined up. Yes, ma'am?
Your Honor, we didn't know they were going to give us a full report dump. What we had been led to believe it was screenshots of a text message or some sort of screenshots taken of text messages that we were waiting for. We only found out recently that they have actually had this phone in their possession since
we
at least
knew it was going to
September.
be no. I remember this being all about a phone dump.
No, it wasn't about a phone dump, Your Honor. It was about text messages that were taken off of a phone.
What's the difference?
The difference is one is a full report by an expert. The other is someone taking their phone and saying, take a screenshot and sending that to the police.
No, you've got a couple weeks to figure it out. You can file a motion on the date of the trial. We can hear it. We have talked about this phone dump. We have talked about, and the images, by the way, are the same thing. You're going to tell me that if they went and took a screenshot of the phone dump, that would be any different? Figure it out. You've got a couple weeks between now and trial. Do you want to file a motion, get it? Basically what I'm doing is I'm telling both attorneys, I don't care. This case is going to trial on April 8th if it's the last one standing, right? This case has been kicking along for too long. And if you can't find and discover the evidence, whether it's the AG's office coming in to cover for the prosecutor's office locally, I don't care. I don't know why the phone dump wasn't done before. And by the way, there's going to be a deference potentially to the defendant, but you're going to have to be able to establish the key issue. The key issue is prejudiciality. How is it prejudicial? And they don't even know what they're going to get. They don't even know what they're offering. They've got about 10 days to figure that out. Thank you. Bond hereby continues. The case sets on the trial docket date. Thank you. We're adjourned.
Thank you, Your Honor.
Thank you. Mr. Burdette, we're going to take care of yours, get you out of here. I need to get Mr. O'Brien now. All right. These two cases are people of the state of Michigan versus Nathan O'Brien. File numbers are 25-13990 and 13991. FH appearances, please.
Jake Carnes on behalf of the people.
Bill Burdette on behalf of Mr. O'Brien.
Thank you. And Mr. O'Brien is now seated at council table. What are we doing in these files today, Mr. Carnes?
Your Honor, it appears that we have a plea agreement in both files.
Okay. Start with 990.
Okay, Your Honor, in that file, the defendant will be pleading guilty to an added count of home invasion second degree and count 3 stalking. And the people will be dismissing all the other counts, the habitual third offender notice, and there is a Killebrew agreement to a maximum of a 12-month jail sentence.
Say dismiss the third, have third,
Yes, Your Honor.
right? And what about 13991?
In that file, the defendant will plead guilty to an added count of larceny 200 to 1,000, a 1-year misdemeanor, and the people will dismiss larceny in a building and the habitual third offender notice. We did not address this on the plea sheet, but in that file, there is joint and several restitution of $1,402.59.
Hold on, 1,000.
$402.59
To who?
to, I believe, to the city of Cadillac. It's the cemetery. One moment.
And so, again, he's pleading guilty to an added count 2, larceny 200 to 1,000,
Yes, Your Honor.
and dismiss the other.
And dismiss the count. Yeah,
Mr. Burdette, is that a complete and accurate statement of the pretrial agreement?
Yes, it is, Your Honor.
1 second. All right, Mr. O'Brien, is that how you wish to resolve today's 2 files?
Yes, Your Honor.
Please raise your hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
You may lower your hand. All right, Mr. O'Brien, you have sworn to tell the truth today. I'm going to believe that it will be the truth. Not trying to insult you, but occasionally people like to come back and then say, I didn't really mean it. I didn't really do it. I just said that so I didn't go to trial. So don't do that, because if you do, I'm going to consider that you just admitted to perjury, because you either lied now or you lied later. Either one way, it's a perjury. What you got there, boss?
If I may approach just to
Thank
save
you.
some time there. Thank you.
Well, that's awesome. All right, now, sir, I'm told you're gonna enter some pleas of guilty today. We're gonna go over those right now. In file 13990, which was back in December of 2024. You were charged with home invasion in the first degree, which is a felony punishable by up to 20 years and or $5,000. And there could be consecutive sentencing for any other convictions arising from the same transaction. Now, there is also sentencing enhancement called a third habitual felony offender. That could increase that maximum punishment within the discretion of the court from up to 20 years to up to 40 years. However, count 1 and the enhancement will be dismissed. Count 2 is a charge of assault, resist, obstruct a police officer, which is a felony punishable by up to 2 years and or $2,000. And as a third habitual felony offender, that could be increased to a maximum punishment of up to 4 years. However, count 2 will also be dismissed. Count 3 is a charge of stalking, which is a misdemeanor punishable by up to 1 year and up to $1,000 and up to 5 years of probation. I'm told that you're going to plead guilty to that count. The sentencing enhancement does not apply or would never apply to a misdemeanor. Count 4 is using telecommunication devices or system for malicious use, such as to terrorize, frighten, intimidate, or harass another person. That is a misdemeanor punishable by up to 6 months and or up to $1,000. That also will be dismissed. However, you will be pleading guilty to an added count 5 of home invasion in the second degree. That is a felony punishable by up to 15 years and or up to $3,000. There will not be a third habitual enhancement that could have just increased that from 15 to 30 years. But again, there won't be that enhancement. Is that what you understood for that file?
Yes, sir.
In the second file, 13991, you were currently charged with a single count of larceny in a building, which is a felony punishable by up to 4 years and or up to $5,000. And there's a third habitual felony enhancement there that could have increased that maximum punishment from up to 4 to up to 8 years. However, count 1 and enhancement will be dismissed if you enter a plea of guilty to an added count 2. That added count 2 would be a crime of larceny where the value was at least $200 up to a maximum of $1,000 in value. That is a misdemeanor punishable by up to 1 year and up to $1,000. Is that what you understood?
Yes, sir.
And if that plea is accepted, count 1 and enhancement will be dismissed. There's another couple terms of the agreement. One of them is that there's going to be restitution, and apparently this would be to the city of Cadillac, and it would be joint and several, which tells me that there's another co-defendant, and I can see that on the information here. That person's name is, oh, actually, I don't, which file does it go to? That there's $1,412.59 apply to 9-1 or 9-0?
That applies to 9-1, Your Honor.
So that means you and Mr. Rawson would be each responsible to pay that amount. Now, the victim would only get that total. Well, let's say Mr. Rawson pays $50. You're still on the hook for the remainder. Now, there's another agreement that there was a cap. Is that right?
Yes, Your Honor, that's on file 90.
Yep.
Yep.
A cap is the most I can give you. Now, this is also called the Killebrew Agreement. The word Killebrew is just a name from an appellate case in Michigan. And it provides that at the time of sentencing, if I don't go along with that agreement, and I sentence you for more than a year, which would have to be a prison term, you would have the right to withdraw your plea and come back to the stage of the proceedings. There's something called a Cobb's Agreement, which I don't do. Cobb's agreements are where I would join in right now and promise you're not going to get more than a year. I don't do those because I don't know anything about you. Make sense?
Yes, sir.
All right. Now, if you enter a plea of guilty, you'll not have a trial of any kind. Does that make sense, sir?
Yes.
Now, your attorney has had it handed to me 2 copies of one document that's called an advice of rights. And you did it, one for each file. It appears to have your signature, and I'm holding them up. Is that your signature at the bottom?
Yes.
Did you read through these rights before signing?
Yes, sir.
Did you understand what you read?
Yes.
And you understand that if you plead guilty and accept that plea, you'll be waiving these rights?
Yes.
Additionally, if your plea is accepted, you'll be waiving the right to claim the plea was a result of some other promise or inducement not told to me. Has there been any other promises, threats, or inducements that we haven't discussed?
No, sir.
And you entered the plea of your own free will?
Yes.
Now, Mr. Burdett has probably talked to you about the sentencing guidelines and probably try to give you an idea as to what he thinks I'm going to sentence you to. The question is besides this agreement that we already talked about, has anyone promised you exactly what the sentence would be?
No, Your Honor.
Knowing all that, do you still wish to enter the pleas of guilty as we discussed earlier?
Yes, sir.
All right. Turn to file 13990FH as to count 3, stalking. How do you plead?
Guilty.
And as to added count 5 of home invasion 2nd degree, how do you plead?
Guilty.
Before the court can accept the pleas in that file, I need to have you tell me what you did that makes you guilty of those 2 offenses. Turning your attention back to the date range of December 1st, 2024 through December 14th of 2024 in the city of Cadillac in Wexford County. What happened? Let's start talking about the stalking. Who was or is Karen Beasy, Kain sorry, Karinbesey. Who is that?
Karen Bessie, she is the mother of 3 of my children.
Okay,
We have been living together 4 years now. This is the second time we've lived together.
okay,
During that time, we've had 2 more kids. The first was born back in 2014. 2 have been since 2021.
okay.
We were living together up until 2 or 3 days prior to this incident. Then we were in an argument. Well, first I should address that we got a lot of text messages back and forth where they having probably some threatening in there, and she wasn't allowing me to see the kids, and I handled it the wrong way. I should have went to the court.
Okay.
But
So what, how'd you handle it the wrong way? Tell me, were there some mess?
by blowing up her phone, repeatedly messaging and calling her phone.
And so did she say, stop texting me or something like that? Or?
I can't recall, I haven't seen the message, really had the time to go review them all the way, but
Okay.
I believe she has said that.
All right, well, this is very particular. The way the offense reads on the information isn't specifically, it doesn't describe the charge very well. For there to be stalking, there has to be repetitive, which it's a course of conduct, so repetitive, at least more than once, 2 or more times, of unconsented contact. So, I'm sorry, and that contact has to make a reasonable person feel intimidated, harassed, frightened, and so forth. So for instance, if you are talking back and forth with her and you guys are exchanging heated words, that doesn't count. A better example would be, and I'm not telling you what to say because I told you earlier, you got to tell me the truth. If a boyfriend and a girlfriend split up and she kicks him out of the apartment and he keeps calling her and she says, stop calling me. And he starts doing Facebook and starts doing text messages. Stop calling me. And she deletes them or blocks them. And then he goes out and finds another way to contact her. That's repetitive, unwanted contact or communication. Bickering back and forth, even if it's, I hate you, you can't make a good tuna casserole, you're a bad mommy, you're a bad daddy, blah, blah, blah. That's not stalking. So that's why I asked you that question. I've got to know, did she say, leave me alone, stop texting me? And I don't know. I mean, just.
Yes, I would say she did.
Okay, well, I don't. Okay. I just got to make sure you get what you tell me is the truth. By the way.
He sounds like he's guessing. It doesn't sound like he's very sure of that.
Remember, I'm the neutral one here in the courtroom, right? Just because somebody charges something doesn't mean it's true. And just because somebody wants to take the benefit of a plea agreement doesn't mean it's true either. That's why you have to describe to me what happened. And if you're telling me you kept texting her and those texts would make a reasonable person feel frightened, and she told you, hey, leave me alone. Is that what you're telling me?
Yes, sir.
Okay. Now, what kinds of things were you saying that would make her feel terrorized, threatened?
I really haven't had the chance to review the text.
I know. I knew you told me that earlier. I knew that answer was coming. So we're going to take a look here because this is where we, as attorneys, have to be prepared. If you're saying, hey, I'm going to take the kids away, and she says, no, I'm going to keep the kids away from you, that doesn't count.
I guess mostly it consists of missed calls where I was calling repeatedly. Then I did mention to her, I am gonna ruin your life or using my kids against me. So, I mean, I could see that as a
No,
pretty good.
I don't. Oh, it's okay, and I'm not jumping on you there, Mr. O'Brien. Yes, sir.
There, it is more alleged than simply text messages if we get into the home invasion.
Why don't somebody ask him questions, that somebody who knows what the police report says? Because so far, we aren't getting there.
Well, Mr. O'Brien, did, after Ms. Boosie told you, stop contacting me, did you continue to contact?
I don't remember ever hearing, seeing her where she wrote that.
Did she ever tell you orally that not to contact you anymore? Do you continue to contact her or attempt to contact her, repeatedly calling a blowing her phone call?
I would imagine she did message me and say that. I don't see them on these messages. These are definitely not all the messages. She didn't give them to you. I would have a copy of all the messages on my phone, but there's definitely lacking some here.
Take just a moment. And everybody take a look at the report. So far, he isn't there. So far, I haven't heard anything that to me is a crime.
Yeah, can I go retrieve my laptop and do that?
Sure.
This is why I love this judge.
We're just gonna recess in place. Thank you. That way, Mr. Burdette, you can speak, Mr. O'Brien. Now back on the record for People versus O'Brien in the two cases. Mr. Carnes has returned with a laptop. Mr. Carnes, you may ask questions.
Thank you. Mr. O'Brien, is it true that at one point, Ms. Bessie told you to stop contacting her and stop coming over to the house?
And hold on, before you answer that, he doesn't have it in front of him. Mr. O'Brien, the home in which you were residing with Miss Bessie, whose home was it? Did either one of you own it?
No, sir.
Was it a house or an apartment?
It was a mobile home.
And what trailer park was it at?
It's actually right by Dickens Hill, right on Sunberg Street.
Oh,
Sunberg.
okay. Yep. And so the two of you were renting that mobile home?
Yes, sir.
Who's on the lease?
The lease was only for a year back in 2019, and then it was just month-to-month basis.
So who was on the lease?
She was.
Were you?
No.
Were you? How long were you staying there before this set of events?
4 years.
So you and Miss Bessie had lived at that residence for 4 years together.
Yes, sir.
Okay.
I have.
Hold on. It's all right. I don't think everyone else over here is. We'll see. Okay. I'm going to come up to another question when Mr. Carnes is looking at, but I'm going to direct this one to Mr. Burdette. Is the home invasion allegedly that they broke into the trailer?
Yes, it is, Your Honor.
And what would the crime inside be that he intended to commit, or the felony? Or was it a larceny?
Well, he broke into the trailer and there was an item, a 2-foot bar lock, white in color, that she used to lock the trailer door with, and that was taken. It was open with a pry bar, the door was.
So there was a bar lock inside the home?
I believe the bar lock was on the door.
Okay, but inside the home.
I believe so, yes, Your Honor.
And so when he broke in, what was the felony alleged that he intended to commit?
Your Honor, it was a larceny of that lock bar. It's also, she believes he stole her car keys as well, which were in. So either of those items would provide the factual basis necessary.
So did he take the bar?
Yes, that's what Miss Bessie told officers.
I'm curious if this prosecutor took the bar.
Okay. Could the bar be seen from outside the door?
I don't believe so, Your Honor.
Okay, all right. And did the bar belong to just her?
Yes, Your Honor.
All right. So if Miss Bessie had wanted to kick him out of the home, did he have any property right to stay in the residence? Even though he wasn't on the lease and lived there for 4 years?
I know he had items in the home, he received
Yeah.
mail.
Just imagine this. If Miss Bessie said, "Get out of the home, you bad dude," would that have worked? Did he have to leave? Or would she have to go evict him through a landlord-tenant process? I don't think you guys have thought this case through well enough.
Your Honor, I have thought this through. I
Yeah,
have
all right.
spoken with Miss Bessie. She did say, and there was an officer present.
Yeah.
Unfortunately, I'm still waiting on something.
Yeah,
She said that she kicked him out around Thanksgiving. He had been gone for more than a week. To me, that he abandoned, if there was anything, and I'm not saying there was any tenancy interest. If there was, I think he abandoned it.
did he abandon it, or was he still trying to reach her and talk to her to rebuild the relationship and have access to his children, and he still has all of the stuff? Unless you got a phone message, and that if he kept trying to contact her, he was trying to rebuild the relationship so he could go back in. That's not abandoned unless he said, "Hey, Karen, we're done. I'm never coming back."
She will also testify this wasn't the 4 years in a row, that most recently he stayed approximately from Halloween to Thanksgiving when he was kicked out again. With her on the lease, there is case law that says a boyfriend who spends the night at the house does not become a tenant.
I know that, not a night. He spent, sounds like 30 days there. If I were to accept this plea, let's just say I did. And let's just say, I don't know, I gave him 365 days. And let's say he wanted to file a claim of right to, or not claim of right, an application for leave to appeal because he thought maybe, I'll take a shot. Some appellate attorney would get assigned to the case, and that attorney would be from downstate, and their entire job is to find errors. If I were that appellate attorney, I would grab this case and run with it. And this county would end up being on the hook for about a $5,000 to $10,000 bill. So when I look at these cases, I'm trying to think about down the road. I'm not trying to say, hey, I only make a decision based upon my fear of an appellate court. But the reason is I'm not going to accept this plea because to me, it's ripe with error. He didn't stay one night. They're gone again. They're off again. Did he abandon his stuff? If she kicked him out, there's no argument. I don't think there's a very good argument that he abandoned his stuff, especially if he continued to try to talk to her and try to, by the way, get into the house of breaking and entering, if that's what happened, to go back in. Was she there at the time, Mr. Burdette, allegedly?
I don't believe she was, Your Honor.
She was, according to the police report, she was there. And according to the police report, he broke in with a crowbar and the door hit her in the face.
All right. Was he going in to get his stuff? Was he yelling, hey, I'm coming in, calls her a bad name, I'm gonna kick your ass, something to that phrase, sorry for my choice of words, but. And yes, if he broke in and he took the bar, got it. But you got to tell me that he didn't have any property rights. And I've got to have some case law that says he did not have any property rights. And I'm telling you, this to me is, I'm not telling anybody what to do. It's ripe for emotion. So I cannot, now the larceny in the building, is that include the something about gasoline? Larceny in the shed. Oh, this is the one.
Unrelated.
That's an unrelated case, right?
Yes.
Yeah. So I can't accept a plea in the home issue with Miss Bessie. I can't accept a plea as to the other file. But if this is a global agreement.
It's not.
So do you want me to continue with the plea on the second file?
Yes, Your Honor.
Mr. Burdette?
My client doesn't wish to do that, Your Honor.
Okay.
And I guess what I'm requesting this time is that we schedule for another final conference. This trial is scheduled for April 8th, which is, it's not gonna go.
It's not gonna go on April 8th,
Right.
okay? All right, the court therefore does not accept any entry of plea. Therefore, we are just treating this as a final pretrial conference. Mr. O'Brien, you need to know that at a final pretrial conference, I have a policy that is the last day to enter a plea pursuant to a pretrial agreement if your case is going. Right now, we anticipate there's at least one or potentially two cases that are ahead of yours, which means realistically yours won't be going. But when it comes to a final pretrial and your case is gonna go, the last day to enter a plea. That's not to pressure a defendant ever. The reason why I do that is because often defendants and prosecutors talk tough until the day they have to have a jury come in. And that's when everybody wants to cut the deal. And then if I cut the deal, I've just called 60 people who have all had to rearrange their lives and schedules and employers and get new employees to come in. I've got to get witnesses here. They've got to subpoena people. You have to subpoena people. And if you come in and then you plead, then I just lost the ability to put another trial there. And I can only do about 25 trials in a year. So it's not to put the pressure on you. It's to put the pressure on the lawyers to make sure that they have exhausted, they have made the best deal or offer they're going to offer. And you guys have, Mr. Burdette has beat up, not physically, but verbally on the prosecutor, and they've exhausted their brilliant skills. That's really important for you to remember, because if we get here and it's final pre-trial day and your trial's on the docket next, that's when the nerves hit. I want you to be thinking about this ahead of time. And again, do not, please do not think, well, that judge is trying to tell me he thinks I'm guilty. Well, I just didn't accept the plea, so, all right?
Okay.
Thanks. All right, bond hereby continues as previously set by this court. We are adjourned on those two files. I'm going to place, actually, no, I'm going to give these back to you and I'll put them in the file. Those are the written pretrial agreements and the devices of rights. Thank you very much.
Thank you, Honor.
Yep, we are adjourned. Oh, all right. Ms. Williams, thank you for being so patient again. You're next taking up the case of People of the State of Michigan versus Aaron Seibel. File 24-13962FH. Appearances begin with the AG office.
Did you see that dude's hair? His hair is to his waistline. I need to know what product he uses. They cannot have Paul Mitchell in jail. For real. If they do, I'm super jealous.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you very much.
I am Jeff Harrison. I'm here on behalf of Aaron Seibel today. He's joined me at the table.
All right, thank you very much. Ms. Williams wins today's award for the best degree of patience this morning. We are here today for a final pretrial conference. Mr. Harrison is stepping in for counsel Robert Hartel from the same office. What are we doing today, sir?
It's my understanding that there has been a pretrial agreement between the parties. I will defer to Ms. Williams to recite the terms thereof.
Ms. Williams?
Yes, Your Honor.
Looks like we have a failure to pay child support. That's a 4-year felony and or up to $2,000 or up to 4 years and or up to $2,000. But there's a habitual offender third, which could increase that maximum punishment from up to 4 to up to 8 years and from up to 2 to up to $4,000. Now, let's find out what the deal is.
Oh, yes, Your Honor. We have submitted a plea offer to the defendant, if he were to pay down his arrears. And I have the exact figure here just based on some conversations and the amount of arrears owed. I believe there is a bond payment of a little over $7,000 to go to the arrears. So if he were to pay his arrears down to a little under $2,400, and plead guilty to one count of failure to pay with a habitual 2, we would agree to an 11-month delay of sentence. And if during that time defendant pays his arrears down by half or 50%, then the charge would be reduced to an attempt. And if he pays his arrears in full, then we would offer or reduce the charge to a misdemeanor disorderly. And we also agree to dismiss the HAB 3 and again have him plead to a habitual 2.
No wonder you left that to her, Mr. Harrison, but I think I've got it.
And the only snag that we have right now is the actual numbers, and I'm glad to hear her say that she has that. Because I don't believe his arrearages currently are below 24.
No, she said if he pays under, I'm gonna, Miss Williams, what are the total arrears at this time?
It was 31,000, over 31,000, but I believe there was a bond payment that was supposed to be moved over for 7,000. And then that would bring the arrears down to that amount. My colleague, I'm sorry.
That's right.
So, yes. All right, so hold on. Let's make sure I go over this together. Or we get it all correct. The defendant again is currently charged with failure to pay child support, a felony punishable by up to 4 years and or $2,000. And there's a third habitual felony offender enhancement, making that a potential punishment of up to 8 years and or $4,000. We anticipate that he's going to plead guilty to count 1 as HAB second, which would make the potential punishment go from up to 4 years to up to 6. However, there's an agreement that he would be placed upon a delay of sentence, which, by the way, sir, is up to 12 months. And then if during that 12 months, you pay your arrears down to half, which we believe $31,000, you'll apply the $7,000 to it, leaving $24,000 left. If you are within the year able to pay that down to $12,000, then the prosecutors agree to allow you to reduce the charge to an attempt to fail to pay child support, which becomes a felony punishable by up to 2 years. However, if you are able to pull a monkey or a rabbit out of a hat and pay it down in full, then you can withdraw your plea and enter a plea to a misdemeanor punishable by up to 90 days and $500 called disorderly person. The disorderly person statute is very broad. It covers a lot of stuff, including, not taking care of a child.
Right.
All right. Did I get that right, Miss Williams?
Yes, Your Honor, you are correct.
Got it. Is that what, and Mr. Harrison's bobbing his head?
I am concurring wholeheartedly.
All right. Mr. Is it Sybil or Seibel?
Seibel, sir.
Seibel, I apologize. Mr. Seibel, is that what you want to do today?
Yes, sir, it is.
Okay.
These agreements absolutely blow my mind. That's a lot of money. That's more money than I make in a year. I mean, let's just be real. Where's he going to get that? How's he going to do this? That's crazy to me.
Has he posted a bond already? Is that?
There has been, yeah, and that's what was applied.
What's he in jail for then? Pre-trial. Is it just this?
I'm in McCausland County.
McCausland.
Yeah,
County.
he's being held on a different charge in McCausland. I'm sorry.
It's okay. I just wanted to make sure I didn't miss something. Oh, what's going on with that case in McCausland then?
I am being Monday.
Okay.
Be let on Monday.
Is it a misdemeanor then? Okay. All right, Mr. Seibel, please raise your right hand. Do you swear or affirm the information, testimony you're about to provide shall be the truth, whole truth, nothing but the truth? You may lower your hand. All right, Mr. Seibel, here we go. Looking back at this date range of 2013 to 2018, probably don't need to ask this question. I just do it if I have it. Were you on probation?
No.
All right, so again, I've already told you what you're charged with. Do you need me to repeat that?
No.
Again, you're gonna plead guilty to count 1 as a habitual offender. Second, there's a pretrial agreement as the sentence. I should tell you this. It's a Killebrew agreement. Killebrew is an agreement where it just applies to sentencing, and it says you and the prosecutor reach an agreement. And when we come back here for sentencing in about a month, if I don't go along with that agreement, which means put you on the delay, put you on probation, all that, then you would have the right to withdraw your plea. By the way, the likelihood of me following this pretrial agreement, really, really high. Okay, want to get you out so you can pay the support. But I don't know, but if I don't, you'd have the right to withdraw your plea. Does that make sense? Okay. That's different when you compare it to something called a Cobb's agreement, which I don't do. Cobb's agreements would be, I would promise you right now, that's what I'm going to do. I don't do that because I don't know anything about you, right? I might get a pre-sentence investigation report and find out that you're wanted in 15 countries because you are the biggest drug dealer and whatever.
That's what it much
Thanks for the sense of humor, Mr. Seibel. Yeah. All right, but anyways, so again, if you plead guilty, the prosecutor agrees that that if I place you on a delay and you are able to pay the arrears down to under $24,000, the charge can be reduced to an attempt, which I told you was a felony punishable by up to 2 years. If you're able to pay them off in full, then the thing will go down to a disorderly person and it won't be a felony of any kind. Now, by pleading guilty, you're going to be giving up certain rights and you'll not have a trial. You'll be waiving the right to be tried by a jury, the right to be tried without a jury if the court and the prosecutor consent, the right to presume innocent to prove guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have it silence used against you, and the right to testify if you chose to testify at a trial. You understand those rights, Mr. Seibel?
I do.
And you understand that if you plead guilty and I accept that guilty plea, you will be waiving those rights. Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be waiving the right to have the claim to the plea was a result of some promise, threat, or inducement not told me today. Have there been any other promises, threats, inducements, forced, arrest, coercion to get you to plead guilty that we haven't talked about?
No.
Are you into the plea of your own free choice?
Yeah.
As to count 1, how do you plead? And as to, hold on, I'll get over that. So I need you to tell me what it is that you did that makes you guilty to this offense. Turn your attention back to March 1st, 2013 through November 20th, 2018 in the city of Cadillac in Wexford County. You're going to tell me what it is that you did. Who is Tanya?
She's my ex-wife.
And who is Dina? Is that the child?
Kira.
Here's the child.
Oh, I'm sorry, Kira. I know her name doesn't appear in here. So is it true that during that period of time you owed child support to Tanya for the care of the daughter?
Yes.
And there was a court order to that effect? Some child support? I'm sorry?
Yes, there was.
All right. And is it true that you failed to pay all of your child support and arrears accrued?
I did, Bill.
Okay. Mr. Seibel? It's okay. I mean, it's not okay, but you're doing fine. All right. And is it true also that for the Attorney General who has to generally file a amended felony information here, is it true that looks like on March 30th, 2011, you were convicted of some kind of felony absconding a bond from Osceola County?
I was.
All right. Ms. Williams, do you believe the defendants provided the factual basis?
Yes, Your Honor, the people are satisfied.
Are you aware of any other promises or introducements?
No, the people are not.
And ma'am, do you believe that I have followed Mission Parole 6.302?
Yes, Your Honor.
Thank you. Mr. Harrison, do you agree with Ms. Williams's responses?
I do, I concur in all three.
The court agrees and finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements of the count and the habitual offender second enhancement. This case will now be set for sentencing. Mr. Seibel will be back here in about a month. We do sentencing in this courtroom on Monday morning. A pre-sentence investigation report must be prepared by an agent of the Michigan Department of Corrections anytime someone's convicted of a felony. This report will include a description of the offense, description of the pretrial agreement, statements, information you make or provide, as well as information about your prior criminal history, and it will score into the guidelines, and it will make a recommendation as it's done. The guidelines are not mandatory upon the court, and the recommendation is not either. The court applies its own discretion within the limits provided by the law. You're going to come get this packet. It's going to be provided to you. You're going to complete it, turn it back in. You're going to be subject to an interview with an agent from that office, and you have the right to have Mr. Harrison present during that interview. Mr. Harrison is going to need to get a hold of you. Now, if you get out of bond, after get out of jail in Mecosta County, make sure he knows how to get a hold of you, okay? He's going to make sure that he meets with you, goes over the report. If there's any corrections or objections or errors, he's going to raise it to the court's attention. All right, Mr. Seibel, when you look at that, first of all, making the payment for the $7,000 was a big way with him. When I look at criminal history, things that I always look at, Mr. Harrison knows it, he hears it every Monday morning and Friday afternoons over in Lake City. I look at prior performance on probation violations, parole violations, and I appreciate the emotion that I saw from you a couple moments ago. When I don't see that, being a father of three, it bothers me. When I look and I have seen people in the past who've chosen to spend all their money on sex, drugs, and rock and roll. I know that's probably not what they're really spending on, but I'm just saying, those things really go a long way with me. But making this effort, if you're able to pay this off, that's a good thing. I hope you have a relationship with your daughter. I do. Good. I'm really glad. That's important. It's also when the parent in this position disappears and has no relation, well, that doesn't bode well. But I'm glad to see that you do, and I trust that you do. So, any questions, sir, today about what we've? Any questions about what we have done today? All right, thank you. Awesome. Good enough. Anything else, Ms. Williams?
No, thank you, Your Honor.
All right, Ms. Williams, thank you very much for your time, and got to get something to hang on the wall. We're adjourned.
Thank you.
Of course, you're probably in a room someplace.
Yes. Did we give the next sentencing date? I'm sorry.
It will come out. It will come out and be mailed to you. But I can tell you, you should probably mark it on your calendar 4 weeks from this coming Monday.
Okay. Thank you, Your Honor.
Yes, ma'am. And you can appear via Zoom, of course, if you choose.
Okay. Sounds good. Thank you.
Yes, ma'am. Right.
That was so much fun, you guys. That was great. Oh my goodness. And I've already started tomorrow's. I'm pretty excited about tomorrow's because and I think Deputy Director is going to really like them too, because he likes show causes, and I found some pretty darn good show causes, if I do say so myself, and I do. And who knows what else I'll be able to find between now and then. But I'm having this new setup and this new system has really helped me be able to do this job a lot better. That's all I can say. Once we worked out some of the technical kinks, yeah, it's been wild how much more I can accomplish. It's faster, it exports faster, it's cleaner, I like it. I like it a lot. And I'm so grateful because I couldn't have gotten it without all of you guys, all of your help and all of your support. And basically you allow me to continue to do this, and you make it a lot easier for me to, which makes me want to continue to do. Oh my goodness. I love you. Thank you so much. Thank you, thank you, thank you. With any luck, I'll be able to keep up the 2 streams a day thing. You know, I figure, I'll keep them in the hour-ish, hour and a half-ish window. Won't be doing the 3, 4, 5 hour long streams that I fall asleep on. And, I'll do one in the afternoon and then one in the evening and then the replay crew minis in between. You guys are going to get so much of me, you'll be sick of me. It won't take long. It really was. I love it. It's so pretty. And it's so functional. And it's so fast. And it makes everything so much better. It's like the U version of a computer. Yeah, thank you. I'm so grateful. I really am. I love it. I love it. I love it. I don't know. We'll see. We'll see if I can keep up with everything that I'm planned, it's going to look something like, if I can do this, if I can do it, and I'm just going to keep trying, right? That's all I can do. I've wanted to do a day stream and a night stream for a long time. I've been talking about it forever. It was one of the goals. When my daughter goes off to college, I'll do one in the day, one in the evening, and then also the replay crew minis. Well, that's kind of almost impossible to do when it takes you longer to export a docket than the length of the docket itself. Plus, I have to watch the entirety of the case to catch phone numbers and addresses and things like that. Very rarely do I run them blind. So if I'm running a 2-hour long stream, I've got, 2 hours that I've watched it, that I've also then edited, which you can add on another anywhere from half hour to another hour or even more, depending on how much audio work there is. And then exporting it. And if it takes, an hour or more to export it, I've got 6 or 7 hours invested into one stream, and then having to do the replay crew minis on top of that. That's why it was so hard for me. If I did, if I got a day of replay crew minis done, that means I didn't have a live stream to run for the evening. It was so bad. I struggled, but I struggled in order to be able to have what we have now. And hopefully with what we have now, I'll be able to do so much more and spend so much more time with you guys and give you even better content than what I was finding before, because I have the ability to now. And again, I'm so grateful for all of you. You did, love, you did. You've missed 2 of them today, didn't you? Were you here this afternoon? I don't remember. Can't remember. It was so much fun though. But I was in such a hurry because I had to go get my baby girl. And now I've got her home with me for 1 week. We get to spend time together. She's going to hate it. I'm going to love it. I'm going to take her somewhere and embarrass her in public because that's what moms do. Oh, you guys are the best. I know, and Fiverr is not the place for it. I'm going with that. I'm still, if anybody knows of people who, like, editing the Replay Crew minis is not that hard. The Replay Crew minis is not that hard. You have to be diligent as you watch through them, and you have to kind of know how the stream is set up a little bit, but it's very easily taught to someone who has basic editing skills. So if you know someone with basic editing skills that knows how to use CapCut, that wants a job making my Replay Crew minis after I stream them, have them get a hold of me. We'll talk. Seriously, I would love to have someone dedicated, a part-time editor dedicated to where I stream it, and then they can do the Replay Crew minis, take that off my plate for me to be able to find more content. Come on, guys. Oh. It's so worth it. I only do it to spend time with you guys. CapCut. It's the editing software that I use. It's not that bad. I pay, they just bumped it up too. It used to only be like $10 a month, and then they went to like $24 a month. I think. But I think you can get away with just the basic. I have to have all the bells and whistles because of the transitions needed and the noise reduction and the audio enhancements and the tools that I use. Mortimer Duke, I love you. I love you so much. I love your witty humor. I get so much joy from you. I really do. I don't always understand the references, like that Crystal Gale reference. I had no idea who that was. Not a clue. I had never seen that woman before in my life. Now, I knew the name Loretta Lynn when y'all were saying Loretta Lynn. But, and I listen to country, so I don't look at it, I don't see it. For the good old snip snip. I'm sorry. Hey, for as much as I have proven that I don't watch movies, I don't watch TV. You know what I watch? Court shows. Because I have to find stuff. My neighbor, he was so hilarious. He's like, "You don't ever watch TV, do you?" I'm like, "No." He's like, "What do you watch?" I'm like, court stuff. Sometimes body cam vids. Like, I just watch YouTube. He's like, "So you don't have cable?" Why would I pay for cable? I have YouTube. It really baffles some people. They cannot believe that I own a TV. I just don't use it. I haven't used it since I became a streamer. I have not watched one darn thing on that TV since I became a streamer. This is my life. I love it. I love it. I love it. I love it. I know, but I listen to country. I don't see it. I don't watch the video. I'm going to go to bed, you guys. Actually, probably not. I'm going to be up a little while editing, I'm sure. I love you guys so much. You guys make everything better. Be safe, be well, sleep sweet, and much love.